General, I'm thinking of an Arkansas versus Texas. It was significant in that case that Arkansas owned the land of the university. So it does seem that Missouri has created this separateness with respect to the liabilities of Mohila. What if, and I'll ask this to the other side, it's not really clear to me what happens to Mohila's assets. I mean, what if Mohila itself dissolves? There are no shareholders. I mean, does your answer change if, even though Missouri is not responsible for the liabilities, it does have an ownership stake in the assets of Mohila?
I think it's clear under state law, Justice Barrett, that Missouri doesn't have that kind of ownership interest in the assets of Mohila. And I would point in particular to Missouri Revised Statute 173.410. This is the provision that makes clear that Missouri cannot take the assets of Mohila and appropriate them. They don't go into the general treasury. It makes clear instead that those assets are under Mohila's exclusive control. So I think as a matter of state law here, we don't have anything like the Arkansas case that you just referenced. And as well, the flip side of that is the provision of state law that likewise says Missouri is not going to be liable for any agreements or obligations or liability of Mohila, so that if Mohila goes out there in the world and harms someone, the state's not on the hook for the damage. And that's another distinction from the Arkansas case, where under state law there, it was clear that a suit against the instrumentality was a suit against the state itself.
Would you have the same position with respect to federal corporations? Like, what about the FDIC or organizations like that? What if the agency didn't want to sue? Could the United States sue to protect the federal government's interests if the corporate identity was separate, like here?
No, I think that our principles would apply with respect to our own instrumentalities. We could, of course, sue to protect distinct rights and interests of the United States. And so respondents have cited some cases, for example, where an instrumentality entered into a contract on behalf of the United States in the name of the United States as its agent, and we had a contract right that we could enforce in our own name. Or there was another case that involved a statutory right in the tax context to offset, and the United States was permitted to sue on that basis because it had its own rights and interests. But we've never done what the states are doing here, and in the absence of any underlying contract right or statutory right or trust right, just asserted this all-purpose ability to blur the distinction between the sovereign and instrumentalities when they're separately incorporated in this way.